afternoon and welcome to this 2024 review of legal developments in the property world. I'm Robert Kelly from Stewart Title and pleased as always to be joined by Ian Quayle of IQ Legal Training, who will be leading us through some of the highlights of the year. I know, Ian, you've been busy and out on the road a lot. Are you seeing much more demand for your services?
Yes, very interesting this year, Robert, that, you've got sort of people wanting webinars, doing lots of webinars, but also quite a lot of face-to-face training. And it's really interesting doing that in that you get a far better flavour of what's causing concerns and issues for practitioners. So it's been a really interesting year for that. Again, as far as webinars are concerned, they've been a delight. Our forums that we do, Robert, are really interesting. Stewart Title supporting me to do sort of what I would class as traditional CPD events, really interesting. And also we've done some conferences this year. We're going to be doing a lot more in conjunction with Stewart Title. They're really interesting too. I tell you what I was reading about yesterday, Robert, just something hot off the press. I was reading the Estates Gazette will be no more as of 2025. I don't know whether you read it or get it, but I've over the years always subscribed to the Estates Gazette, get it every week. I have to say in the last 6 months or so, the quality of sort of legal content, case law articles, etc., has declined, or rather the volume rather than quality of content has declined. So it comes as no surprise. But yeah, it's been an interesting year. Lots of things to talk about today. With regard to what's happened in 2024. We're going to have a sneaky peek at what I think might be happening in 2025. But Robert, from Stewart Title's perspective, what sort of year has 2024 been?
It's actually been getting faster and busier all year. We've had October and November were our best 2 months for the Stewart Solution Online programme for probably the last 2 or 3 years. And obviously the good thing for the industry from that is our policies only tend to get bought at the last minute. So that means hopefully that there have actually been completions, people moving house and fees for lawyers. So it does seem to be picking up. We're looking forward, like you, for next year. We're currently just completing a round of new hires and we've got 4 new underwriters starting in the new year. So we'll be telling people more about that. And also looking at some new products. Which we'll be again talking about at the start of next year. And yeah, looking forward to getting out and seeing people again. Looking forward to trying to help you steer away through all of the changes in the law. I know today you've got the good old BSA there, but also I see Common Hold is back. I thought that was like a good idea from 20 years ago, we'd forgotten about, like the cheeky girls. But it's back, is it?
It's well and truly back, Robert. Well and truly back. I tell you what, Robert, you're saying about your new underwriters. One of the things that's really interesting, as you know, I'm doing a bit of work with one of your underwriters, Neil, at the moment, and it's just how much knowledge they have with regard to claims, etc. And you and I were speaking at a conference just recently, and you were saying that from a conveyancer's perspective, you know, the fact that Stewart Title have underwriters sort of sitting at their desks or looking at their screens, quite a useful resource if you've got a sort of unusual defect in title or a problem with regard to a defect. As a sort of sounding board. And I mean, obviously you can do that and your colleagues in business support can do that and business development, but you've also got underwriters sort of sitting back at base camp that can also sort of shed light or provide views and opinions.
Yeah, I mean, that's one of the things is that, you know, like you, as when I was a lawyer, I bought policies and very rarely saw or was aware of a claim on any of them. But our guys here see claims and see problems every day. That's their bread and butter, is to see these types of problems. So they quite often have a different insight on problems and are quite useful actually on finding ways around them. And also really just sometimes it's difficult. You know there's a problem as a lawyer, but you can't quite phrase it properly. You aren't quite certain what you're looking for in the way of cover. So our guys' experience is incredible, and they can lead you to a better solution there. So you're very happy to talk to people there, and also very happy for those of us, Ted and Freddie and I in the BD team, and Liz in Scotland, to talk to lawyers and try and point them in the way towards some useful policies. So very helpful very keen to do that. But I suppose at the moment, very keen to get on with the review so that you can try and give us some comfort and guidance at the year end.
Happy to do that, Robert. Anyway, so we'll get cracking. Thanks, Robert, and thank you everyone for coming along today. As usual, the webinar is recorded. It will last approximately 1 hour. As it's a review of the year, there aren't any notes, but slides can be available. If anyone has any burning questions or issues, there's a question and chat facility that you may utilize. I will scrutinize those before we finish. If you have a burning question or any comment, etc., that you'd like to make and we don't have time to deal with, or technology lets you down, do drop me a note by email and I'll happily assist and respond. If you have any inquiries about Stewart Title's product, again, ping Robert an email and he and his team will happily respond as well. So there's some detail about Stewart Title, hopefully with Robert's contact details on it. If not, I'm sure Robert can put something in the chat, and I'm sure there's a slide towards the end with contact details on there. Useful websites. Over the year, I've spoken about all of these websites. There is a new website that I want to mention, penultimate bullet points, the Property Institute. The Association of Residential Managing Agents, I think, is no more, and I think it's been incorporated into an organization called the Property Institute. As a consequence of that, there is additional guidance and case law updates with regard to residential leasehold transactions. So it's quite an interesting site. I've had a look at it on 1 or 2 occasions. I haven't used it for research recently, but I will be doing so shortly. And of course, Stewart Title do sponsor Property Law UK, our monthly electronic publication, which comes out last Wednesday of every month. And again, that's gone from strength to strength with the support of Stewart Title. If anyone's interested in seeing a copy of that, the December edition, which is a special edition, will be a free edition. Just drop me a note or drop Robert a note and we'll make sure that you're on our list and you get a copy of it when it's produced, which I think is be sometime next week. Interesting reading over the holiday period if you are have had enough of children, parties, etc., and you want a little bit of quiet time to do a little bit of research with regard to the law. Property Institute, have a look at. Leasehold Advisory Service, Leasehold Knowledge Partnership, I've told you about. Property Protocols, Boundary Dispute Protocol, really useful for residential conveyances. Okay, so Robert mentioned the Building Safety Act, and I couldn't leave 2024 without having a review of the Act. First point, despite the sort of protestations of government, despite some clarity on some issues being resolved or decided by first-tier tribunal, my view is that over half of residential conveyances are not touching Building Safety Act issues. When talking to insurers, they're telling me there aren't any claims relating to negligence concerning Building Safety Act as against solicitors or conveyancers. I would say, well, one, they're not seeing the true marketplace, because if most firms aren't doing BSA related work, there's not going to be the number of claims that you normally expect. And secondly, and importantly, it's early days as far as claims are concerned in connection with BSA transactional stuff. First point. Second point, we haven't seen rafts of case law involving the Building Safety Act insofar as it relates to conveyances. We've seen lots of matters going before first-tier tribunal and upper tribunal where landlords or building owners are fighting against themselves as to who is responsible for remediation costs, or we've seen litigation in connection with landlords or building owners against previous landlords and building owners with regard to apportionment of remediation costs. But we're not seeing case law that you and I can look at and say, right, I now understand if I'm acting for a seller or if I'm acting for a buyer, exactly what I'm going to have to do. There's one case where I think there's been some useful guidance, but there isn't a raft of case law that I can point to you as solicitors or conveyancers doing transactional work and say, there you are, we now have a definitive answer to the multitude of questions that the BSA, regulations, law society guidance, and indeed government guidance has generated. In addition to that, hot off the press, if we look at this slide, the government has published 2 major initiatives concerning Building Safety Act issues. The first of which is something called the Remediation Acceleration Plan. This was generated because research had been done by a number of organizations that said, given the amount of buildings that are unsafe due to cladding, due to other fire risk issues, the amount of time that it'll take, assuming landlords have the funds to pay for it, will be inordinate. In addition to that, the appetite from some landlords and building owners to get on with remediation has to an extent been limited in scope. A, because if they can't recover costs from leaseholders, why should they incur the cost unless they're sort of pushed into doing so? And B, because some landlords simply don't have the funds or the facility to pay for remediation. So government decides, let's come up with a remediation acceleration plan. Let's impose deadlines for remediation work. And when we're imposing deadlines, let's look at high-rise buildings, which potentially are the equivalent of higher risk buildings under the Building Safety Act. And let's have a look at mid-rise buildings, which are potentially buildings that are relevant buildings for the purposes of the Act. And interestingly, no remediation acceleration plans for relevant buildings that exceed 5 stories. Sorry, no plans for remediation for buildings that aren't relevant buildings. In other words, buildings that are smaller than 11 meters in height. So what we've got is deadline 2029. Unsafe cladding has to be removed from high-rise buildings. With regard to mid-rise buildings, then again, unsafe cladding has to be remediated by the dates shown on slide. And again, sanctions and penalties for non-compliance. So 2029, the year by which cladding issues in connection with high-rise and relevant buildings are going to have to be addressed and rendered safe. When we talk about penalties for landlords who fail to act, I think what we're talking about here is potentially criminal sanctions. I fail to see how financial penalties can be imposed when, at the end of the day, finance should be utilized for the purposes of remediating defective and dangerous buildings. Next thing, tougher enforcement measures, remediation orders. The first tier tribunal, upper tribunal, having jurisdiction to do something that a first tier tribunal has already done, as I'm going to show you in a minute or two. So the idea here is that the first tier tribunal, when dealing with a remediation issue, can require a landlord to do specific work, so they can actually tell the landlord what they've got to do and specify the time frame for doing it. And again, non-compliance leading to criminal sanction, fines and/or imprisonment. Again, if this comes to pass, bet your life you're going to see developers and landlords being terrified about building safety management issues if they're not terrified already. Next thing, remediation contribution orders, allowing leaseholders to recover costs by applying to the property chamber of the first tier tribunal to seek financial contributions from developers, landlords or associated parties. So enabling leaseholders more access to sort of self-help with regard to funding. Support from leaseholders, again, item D on this list. A really interesting development, this. What I think government is driving at is situations where a leaseholder who has been held liable to pay service charge for what would be remediation work for relevant defects as defined by the Building Safety Act, being entitled to recover what they've already paid to landlords. So if you're acting for a seller and your seller has paid in 2021 service charge a cost for remediation work for relevant defects, the idea is that the leaseholder can recover that from the landlord. Now, again, when we talk about recovering previously incurred remediation costs, are we saying costs that have been incurred post 2022, or are we going further back than that? My gut reaction it will be that the costs will be cost incurred and paid by leaseholders post June 2022. But we'll have to wait and see on that. A plan to enable developer-led remediation excuse me, to be accelerated and to improve resident experience. In other words, to make sure residents are informed, residents are aware, residents have highlighted to them potential costs that are coming down the line with regard to remediation work for relevant defects. This is all planned by the government. This is rhetoric at the moment, but it seems to me, given that this has been published, the government is not going to retract or move away from it. It might be to an extent watered down. It might be that time limits are extended. On the issue of deadlines for remediation, talking to a company that specializes in remediation, their order book is full. They're not taking on any new work. And they're saying to me that there aren't the specialist remediators available to meet demand if every landlord in connection with every unsafe building requires work to be done before 2029. They're just saying that's impossible. It's like the government's promise to have 1.5 million homes built. Fantastic, brilliant idea, brilliant principle. Have we got enough bricklayers to build 1.5 million houses in 5 years? Those that are far cleverer than me and far more knowledgeable about this particular topic than me are saying there ain't the bricklayers out there to pick up the slack and to get this work done. So interesting. I'm just drawing to your attention what we've got with regard to government intent relating to the Building Safety Act. The next thing that I want to show you, if I may, is this case of Lena against Land Street Management. This is the nearest we've got so far to a first-tier tribunal saying to residential conveyancers, this is what you need to do in order to comply with the Building Safety Act. There is an appendix to the judgment in this case where the tribunal is telling practitioners, these are the questions that you've got to ask. Some of these questions are repeated in the Law Society guidance. Most of these points are contained in the Law Society book on the Building Safety Act 2022, which is still proving very popular, and again getting lots of people having read it saying we now understand how the Act works and what we can do. So again, quite supportive of what we've said in our practical guide to the Building Safety Act, still available from the Law Society. Sorry about the plug. So preliminary conditions. Are we dealing with a relevant building, or are we dealing with a higher risk building? Or are we dealing with a building that is neither a higher risk building or a relevant building, which could be subject to airspace development, so it becomes a higher risk building or relevant building? Whether it becomes a relevant building or not doesn't really matter that much. Whether a building could become a higher risk building is significant, as we'll see a little later. And the tribunal refers to section 117 of the Building Safety Act when dealing with relevant buildings. Section 120 is the service charge in dispute relevant to a relevant defect. In other words, a defect concerning fire safety or risk of collapse. And then is a service charge a charge relating to a relevant measure? A relevant measure, remediation work required to remediate a relevant defect. So again, as far as those questions are concerned, what's the status of the building in which the flat or the apartment is situated? If there is service charge or has been service charge in the past, has it been a service charge cost relevant to the remediation of a relevant defect? Next point, does paragraph 2 schedule 8 provide protection? Well, schedule 8 paragraph 2 refers to relevant defects that require remediation where the party that originally did the work that now requires remediation was either the landlord or an associate of the landlord. So it's important to ask, if there is remediation work for relevant defects, who did the work in the first place that now requires remediation? If it is the landlord or an associate of the landlord, paragraph 2 of schedule 8 bites and states any leaseholder, residential or commercial, in a residential context, whether you own a qualifying lease or not, is protected. A landlord cannot transmit remediation costs for relevant defects where the landlord did the original work that now requires remediation. The next issue that you've got to determine, courtesy of Lena, is the service charge in dispute payable after the 20th of July 2022? Because theoretically, Schedule 8 and its protections will only apply in those circumstances. Next question, was the landlord required to produce a landlord certificate? Remember, landlord certificates required where there is a triggering event. Most common types of triggering event: leaseholder asking a landlord to produce a landlord certificate, or leaseholder notifying a landlord of the leaseholder's intention to sell, or landlord wishing to incorporate within new service charge the cost of remediation of relevant defects. So we need to ask, has the seller got a landlord certificate or landlord certificates? If so, when were they produced and why were they produced? What was the triggering event? And did the landlord produce the certificate within the 4-week window that the Building Safety Act and regulations prescribe? Remember, if a triggering event occurs and the landlord fails to produce a landlord certificate, the landlord cannot incorporate within service charge remediation costs for relevant defects that it was aware of prior to the date that the certificate should be produced. But also remember, a landlord can always issue a new certificate where the landlord becomes aware of new remediation work or new relevant defects that require remediation. So there's a very important practical point here. A failure by a landlord to serve a landlord certificate does not mean the landlord cannot ever recover remediation costs for relevant defects. If a landlord at a later date discovers remediation work for relevant defects, provided the landlord issues a new landlord certificate, provided leaseholders are not fully protected under Schedule 8 of the Building Safety Act 2022, the landlord can incorporate those costs within the service charge and leaseholders would be obliged to pay it. Next thing from Lena, is the lease a qualifying lease? An important point here. If a lease is a qualifying lease, if it meets all the criteria required under the Building Safety Act as of the 14th of February 2022, then a leaseholder deed of certificate should be produced, and that certificate is a golden ticket. It means that any leaseholder acquiring that lease at any point in the future is granted the maximum amount of protection that Schedule 8 of the Building Safety Act provides. Now, again, Schedule 8 of the Building Safety Act does not provide blanket protection for all remediation costs. It provides some protection for some remediation costs, as we'll see in a moment or two. Remember, to be a qualifying lease, the lease has to be granted before the 14th of February 2022. It has to be a lease of a residential long lease. In other words, the original term has to exceed 21 years. And the service charge provision in the lease must be for a service charge that is not fixed. In those circumstances, if all those criteria are met, we then have to look at who the leaseholder was as of the 14th of February 2022. If the leaseholder only owned this flat, which was his or her home, or the leaseholder owned this flat and no more than 2 of the dwellings in the United Kingdom, the lease is a qualifying lease. If the lease is a qualifying lease and that flat is sold, whoever acquires the lease also has the protection of qualifying lease status. So what is the protection of qualifying lease status? Well, we'll just go through some of the aspects of Schedule 8 that highlight what the protection is. If a landlord met the contribution condition as of the 14th of February 2022, in other words, the landlord had assets that exceeded £5 million as of that point, the landlord cannot transmit remediation costs for relevant defects into the service charge of qualifying leaseholders. Paragraph 4 provides protection where a lease as of the 14th of February 2022 had a value of less than £350,000 inside Greater London, £175,000 outside of Greater London as of the 14th of February 2022. Again, landlords cannot transmit remediation costs for relevant defects to leaseholders in those circumstances. Where the lease exceeds those values as of the 14th of February 2022, there is a cap or ceiling. The initial cap or ceiling is that service charge cannot exceed, for remediation of relevant defects, £10,000 for flats outside of Greater London, £15,000 within them. Where the value of the flat increases as of the 14th of February 2022, that cap or ceiling increases as well. If you own a qualifying lease, the landlord cannot transmit remediation costs relating to cladding into your service charge. The landlord cannot transmit irrecoverable costs from qualifying leaseholders into non-qualifying leaseholders' service charge, and a landlord cannot transmit legal and other costs incurred in connection with remediation work into the service charge of qualifying leaseholders. So if there's legal costs or management costs incurred in connection with remediation work for relevant defects, and you own a qualifying lease, the landlord cannot transmit that cost into your service charge. Landlords can't exclude the application of Schedule 8, nor can they use reserve or sinking funds or the right within the lease to borrow money to circumvent the protection that Schedule 8 applies to qualifying leaseholders in most cases and all leaseholders in connection with paragraph 2 of Schedule 8, where the landlord or associate of the landlord did the work that now requires remediation. So, Lena, a really interesting case. Have a look at it. There's more than I've just mentioned on those two slides there. Bromfield against Monia Road is a bit of bad news, to be honest with you. This was a case where the tribunal was having to determine if a building was a higher risk building. So it was calculating the number of stories in the building. The government guidance says that you ignore a roof garden in calculating the number of stories. This building had a roof garden. If the roof garden was not a story, the building was not a higher risk building. If the roof garden was a story, then the building was caught by the definition of a higher risk building. Landlord says it's not a story, it's not a higher risk building. Leaseholders were saying it is a story and is a higher risk building. The consequence of that is increased duties and obligations on landlord with regard to building safety and remediation. The first thing the tribunal did in this case was it compelled the landlord to undertake extensive remediation work and specified what had to be done. So in the past, what tribunals have done is said, this needs remediating. And it was down to the landlord how the remediation actually was undertaken. In this case, the tribunal says, no, we're going to tell you what you need to do. We've had expert evidence put before us. This is what you need to do. Another thing the tribunal said is, we're going to give you a deadline. You've got until September 25 to get this work done. So again, landlord says, you can't do that. Tribunal says, just watch us. So a few interesting things. One, how we calculate a higher risk building. Two, the tribunal basically doing that which the latest government guidance, which we saw on the 2nd of December, earlier slide in my presentation, is now expecting the tribunal to be able to do. On the issue of the height of the building and number of stories, the tribunal was at loggerheads with government guidance. And as a consequence of this case, if you look at the current government guidance, it says that the tribunal made a decision in Bromfield, and the building safety regulator and relevant government department are now considering what the tribunal had to say. In other words, we're thinking about it. But what the government guidance says is, in the meantime, you should continue to refer to existing government guidance. So we've got a first-tier tribunal saying one thing. We've got the government guidance now saying, well, we're thinking about the position, but in the meantime, stick with the guidance. There's got to be, in my view, some clarification of the point. And I think what's going to happen is that an upper tribunal is going to say either you follow the government guidance or you don't. In Blomfield, the tribunal said, what is government guidance? It's advice from a government department, not a court, not a tribunal. It has no legal consequence and no legal effect. We, as a first-tier tribunal, or our superior, the upper tribunal, or the appellate courts, are that which creates law where the Building Safety Act is unclear, vague, or ambiguous. And I have to say, ladies and gentlemen, there are loads and loads of examples of the Building Safety Act being unclear, vague, and ambiguous. Next case, Alma-Cantor Centrepoint against leaseholders. Really interesting case this, which shows the current thinking of first-tier tribunal and upper tribunal. There are lots of cases I can show you where the first-tier tribunal and upper tribunal in BSA-related disputes are saying the Act and the regulations are a mess. So what we're going to do is go back to first principles. What's the reason for this legislation? It is to protect leaseholders, and we will make decisions on that basis. So in this case, you had a landlord that said, when we talk about cladding systems and repair or replacement or removal of cladding systems, what we're talking about is the outer wall of an external wall system. And on the facts, we're prepared to take that down and reinstate it. The tribunal said, no, you've got this wrong. When we talk about cladding systems, we don't mean the external wall, the facade of the building. We mean underlying insulation and cavity barriers. In other words, we interpret cladding in its widest possible extent. The tribunal said that the leaseholders were right, that what we need to do is think about cladding in its widest possible definition, and that would include the underlying insulation and cavity barriers. Again, regulations and Act don't specify or provide detail. Tribunal says our aim is to give effect to what Parliament intended with regard to this legislation. Parliament intended leaseholders to be in a safer position as a consequence of the Act than they were before it. Simply allowing a landlord to remove part of the cladding does not generate the protection that the Act expects of leaseholders. So it shows you the spirit and scope of the legislation, and more importantly, in my view, the attitude of tribunal. The next thing to tell you is we've got not many cases, as I mentioned in my introduction, that provide clarity, but we've got some cases that are due to appeal. URS Corporation against BW Trading, due to be heard at the end of this month or later in this month before the Christmas break. You've got Adriatic Land and Hippersley Point due to be heard as well. You've got a number of cases being heard in March 2025, including the case that everyone's heard of, Triathlon Homes and Stratford Village Development Partnership. So later this month, early sort of or mid quarter one, towards the end of quarter one 2025, I'm hoping, fingers crossed, and ever the optimist, that we're going to have Court of Appeal and Supreme Court decisions that help us as conveyancers to negotiate the complexities of the Building Safety Act. So it's going to be interesting. Currently, we've got lots of clarification about disputes concerning remediation contribution orders, where landlords and building owners are fighting as to who's responsible for what. But we haven't had the clarity that we'd hoped with regard to the procedural issues relating to the conveyancing process. And until we've got that, this stalemate, this impasse, and this blockage, as it were, with regard to transactions, as far as I can see, will continue. So again, we've got Alma-Cantor appeal 18th and 19th of December, so next week. Again, we might have some more clarification on procedural issues as a consequence of that case. Next thing, what can we say about 2024, the debacle concerning TA forms? And I know the Law Society is coming with a bit of flack about TA forms. I have some sympathy for the Law Society, because I think what's happened is government has lent on the Law Society to say this idea about material information is important. We want buyers to be aware of issues relating to the negotiation process as early as possible in the transaction. We want you to amend the TA forms that are within your control to enable material information to be generated for the assistance of estate agents and prospective buyers. The Law Society made an error in forcing this through. The Law Society made a further error back in June to say, all right, we'll extend time to allow consultation to take place, and not giving themselves enough time to enable consultation to be concluded, and then for a long, hard look at the revised TA form, consultation comment from the profession and others, and then a time to reflect before the revised TA form goes live. We have got government saying and Law Society saying there's going to be a pushback from January. We don't have a date when the revised TA6 form will go live, but it seems to me, given what's happened, the Law Society is going to push through with it. So anyone thinking the revised TA6 is sort of dead in the water, I think has got things terribly wrong. With regard to the revised TA6 form, I think there are a number of issues that worry me. Firstly, there are questions, lots more questions, some of which are far more wide-ranging and which clients are going to struggle to answer. But the basic premise that the TA6 is completed by the seller in isolation without advice or assistance from a conveyancer continues. So how does that work? How could we have sellers completing TA forms when they don't understand the question and therefore can't answer the question, or where the question is potentially wide-ranging and negative or incorrect or defective responses could lead to liability for misrepresentation? I think we've got a problem. I think all we can do with regard to the use of the revised TA6 form, if we are using it or if we have to use it, is provide some basic advice to clients. And to do that, I think we warn the clients as to the warnings as to the current TA6 form about the potential for liability. We provide sellers with information sheets about the questions that the TA forms are asking about, highlighting terminology and what it means, explaining to sellers the potential vulnerability for misrepresentation claims, the need to give full and frank responses, and our role with regard to what the seller says. In other words, our need to check what the seller says in the TA form against the information that we hold on our seller's file, and to highlight to the client the potential dangers of guessing answers, answering questions that they don't understand, answering questions in an effort to sort of encourage the buyer to proceed with the purchase, with the knowledge that there is information that if the buyer was aware of it, might detract from the buyer's decision to proceed. There's been some case law that adds a gloss on all of this. I mentioned at the bottom of this slide, the revised TA6 form includes questions concerning building safety. And the revised TA6 form, in my view, contains questions that ought properly to be included in the revised TA7 form. And before we leave this slide, the revised TA7 form, I think, does not give a buyer all the answers the buyer's conveyancer needs concerning the Building Safety Act. So I am telling sellers solicitors that you can expect additional inquiries from a buyer where a property has BSA issues and the buyer is properly advised. So, for example, the TA7 does not ask the seller to confirm when a landlord certificate was received, or does not ask the seller to confirm when a leaseholder deed of certificate was served on the landlord, or when a landlord requested a leaseholder deed of certificate from the seller. All of these questions are important and significant as far as determining to what extent the Building Safety Act affords protection. The TA6 form asks about restrictive covenants that affect the use of the property. So again, is that just asking what are the covenants that are listed on the title? Or when we talk about affecting the use of the property, is that not implying the seller answering whether or not the covenants are in fact enforceable? And if so, by whom? Again, caution needs to be exercised. Look at the bottom of this slide in Japanese knotweed. The question has now been refined. So it's not just asking the seller about their knowledge relating to Japanese knotweed in connection with the property, but adjoining or abutting property. So how on earth is the seller going to be able to confirm that they've checked that neighbouring or abutting properties have been inspected to determine the existence or otherwise of Japanese knotweed? Impossible. So I think these new questions are going to lead to the potential for greater vulnerability for the seller if the seller gets something wrong, and therefore the seller client needs to be told to exercise caution with regard to how these questions are answered. And of course, all of this defeats the object, doesn't it? The whole idea of the TA forms is that the seller is providing useful and reliable information to the buyer that the buyer can rely upon. But the more complex the questions, the more potential vulnerability to a claim for misrepresentation, the less likely that the seller is going to volunteer information. I mentioned TA6 now includes questions about the type of leasehold property, etc. And again, there's some duplication. And my view is that those questions should be properly included in the revised TA7 form. So we've got an extension of time. Law Societies say we decide to extend the period that both forms can be utilised until we've completed the consultation process. So January 2025, not an issue, but we've got to wait and see when things become live and operable. Again, on my travels, I am encountering firms who are acting for buyers who are telling me that the seller has used the revised TA6 form. I'm not encountering many sellers firms that are voluntarily using the revised TA6 form at the moment. Okay, we've talked about that. Right, Rosser and Pacifico, important case. Important case because seller successfully sued for misrepresentation. Buyer buys what she thinks is a two-bedroom flat. When applying for a license to let the property, it transpires the flat can only ever be let as a one-bedroom flat. What was a second room that was described in the estate agent's particulars as a second bedroom and laid out by the seller as a second bedroom could not be used as a second bedroom because a Velux window installed in the ceiling of that part of the building hadn't got planning permission and hadn't got building regulation consent. The building was a listed building. So when someone comes out to inspect the property for licensing purposes, they contact building control come out and say the ceiling has to be reinstated, the roof has to be reinstated, therefore what you're purporting to be a second bedroom can't be a second bedroom, no natural light, no ventilation. Seller is sued on the basis of 2 points. One, it had answered incorrectly, I think it's question 4.4 in the original TA6 form. Seller stating it was not aware of any breaches of planning permission conditions or work that didn't have all necessary consent. Okay, so that's a sort of standard misrepresentation claim with regard to a defective response to a question in the TA form. But the buyer also sued the seller for misrepresentation on the basis that the estate agent had provided the buyer with drawings and specifications that showed what was a front room in the property as a bedroom. And another point put before the court is when the buyer inspected the property, the front room was laid out as a bedroom. So any reasonable person inspecting the property as a prospective buyer would think that this is a second bedroom, therefore I'm purchasing a two-bedroom flat. The court held that the seller was liable for misrepresentation. Firstly, because the answer no given by the seller in question 4.4 in the TA6 form carried an implied representation that the seller developer had reasonable grounds to believe that there was no work that had been undertaken that didn't have the necessary consents. Now, it may be that a court in the future will say Rosser and Pacifico is limited in its scope and extent to situations where the seller is a developer, and the developer, who should be aware of planning and building regs and know how to inquire about planning and building regs, fails so. Whether that extends to a traditional seller in a traditional conveyancing transaction, I don't know. But at the moment, we've got this case where a seller was held to be liable in connection with a defective reply to a question in a TA form because it didn't check before answering the question. And the other ground, the provision of information by the estate agent on behalf of the seller to the buyer was a representation that was false, and the seller was therefore liable to the buyer for the false statement, for the misrepresentation made by the estate agent in providing information to the buyer that was incorrect. So what can we extract from this case? One, be careful to make sure that where information is transmitted from an estate agent to a buyer, you see it if you're acting for the seller, and warn the seller that they could be liable for any information that is transmitted in that manner. And two, warn a seller when they're answering questions in the TA form that they should undertake reasonable investigations before answering the questions that are posed. Now, with regard to the revised TA6, where the questions are, or where the TA6 form is saying to the seller who's answering the questions, you may need guidance or assistance from your solicitor, or you may need to visit websites, etc., before you answer this question. I think what you've got to say to the seller is you've got to do as the form suggests before you answer the question. And where a seller contacts you to ask for information concerning restrictive covenants or informal rights, I think you've got to be very guarded how you answer the question and explain to the clients what informal rights are, what restrictive covenants are, and where they can find out about them or where they may have knowledge about them. But to make sure that the seller client understands the answer that is given is the seller's answer and not the seller's answer based upon advice that you've provided. So in Rosser and Pacifico, the seller said, this is nonsense. Caveat emptor applies. Buyer had experienced conveyancing solicitors who could have performed due diligence, undertaken searches, made investigation of planning and building control to find out all about these things. The trial judge said, that misses the point. Caveat emptor is limited in its scope. The conveyancing process allows standard questions to be raised of the seller, with an expectation that the seller answers the questions honestly. The buyer is entitled to rely on what the seller says because the seller will have far greater knowledge of the property than anyone else. The seller should make reasonable inquiries before answering questions if it doesn't know the answer, because the buyer is going to rely upon it. And the judge also said the front face of the TA forms warns the seller in quite obvious, clear language about the risk or vulnerability for providing defective replies. I think the net effect of Rosser and Pacifico is sellers need to be warned very carefully in the retainer when the TA forms are sent out to the client about the dangers of providing incorrect replies. And when the response comes in and the TA forms are returned by the client, you should check what's said against information that you hold on file, and again warn the seller client about the need to provide an update if information changes, and about the potential vulnerability for misrepresentation if answers are incorrect or defective. Not going to talk about the Japanese knotweed case Downing and Henderson, other than the revised TA6 is asking the seller to confirm about their knowledge with regard to Japanese knotweed on the property that's being sold and adjoining and abutting properties as well. No way can a seller properly advised answer the question relating to Japanese knotweed other than I don't know. The next thing, as Robert mentioned, common hold. The King's Speech 2024 introduced the draft leasehold and common hold reform bill with an aim of reinvigorating common hold. It's also restricting the sale of new leasehold flats. And the government is going to consult on a lot of these issues. But Common Hold Leasehold Reform Act 2002 has all the necessary building blocks in place to enable this government, or indeed any future government, to relaunch Common Hold at any point in time. First thing, don't worry, we're not going to see on the 1st of January Common Hold being relaunched and being activated in April 2025. I think what will happen, what ought to happen, is that if Common Hold is going to be launched, if the government is serious, the profession will need at least 2 years in order to get to grips with what Common Hold is and how it works. That's what happened under the Common Hold Leasehold Reform Act 2002. Now, again, I'm not at this point in time suggesting that Common Hold is good, bad, or indifferent. All I'm saying is it's out there. 6 or 7 firms have asked me recently about if I can do training on Common Hold. So they're of the view that medium term we're going to be dealing with it. Being the skeptic that I am, I sometimes wonder, is the government doing this on the basis that they're waving it as a sort of an imaginary stick in the hope that developers and builders will play ball with government with regard to leasehold reform? Because I'm fairly confident that's what the former government did back in 2021. But it's important that you understand the following. Common Hold is freehold ownership of flats and apartments. What you have with Common Hold is a landlord being replaced by a Common Hold association, a company with a statutory constitution that can't be altered, with what were leaseholders now being called unit holders, being members of the Common Hold Association, and basically who manage what was the landlord's title, but which is now the freehold title of a Common Hold Association. So the landlord disappears, replaced by a Common Hold Association owned by unit holders who are the new type of leaseholder. However, a unit holder doesn't hold a leasehold interest. He or she owns a freehold interest in their flat or apartment. We have a Common Hold Association with standard documentation. We have a Common Hold Community Statement, which is, in essence, the provisions within a lease, within, again, another standard document that regularizes the relationship between the Common Hold Association and unit holders, and the relationship between unit holder and unit holder. So the Common Hold Community Statement takes the place of and is nothing like a residential long lease. Again, it is a standard document. So if we're looking at Common Hold schemes, we're going to see standard documentation, and we're not going to have to trawl through a lease to find out forfeiture provision or service charge provision, etc. It's going to be standard. No matter where the scheme is, northeast of England, southwest of England, the documentation and wording behind the documentation is going to be the same. Do we need to worry about its introduction? I think we need to be aware of the existence of this concept of Common Hold, and I think at some point, if I'm right about government, and the government isn't just using this as a stick, then we're going to see Common Hold. I think what we'll see is it being used in connection with new builds, but the Common Hold Leasehold Reform Act 2002 does permit the conversion of existing leasehold buildings into Common Hold schemes. So the conversion of a landlord and tenant relationship into a Common Hold Association and unit holder relationship, and the conversion of standard leasehold documentation into a Common Hold Community Statement. So I don't say worry and sort of get concerned over Christmas about getting up to speed with Common Hold. Be aware of it. I am running courses on Common Hold in January. My aim is just to generate awareness, just to make sure people are familiar with process. As and when government launches Common Hold or relaunches it more accurately, then we'll have a look at some more in-depth training. What does 2025 hold for the conveyancing profession? Well, I think there are a number of things that's important. Because everyone's been so busy, and I think because we're going to be busy in 2025, particularly with SDLT issues, etc. I think it's important that we take time out to review documentation and processes. Are we CQS compliant? If we are CQS compliant, have we reviewed systems and processes? Have we got data about the sort of work that we're doing? So we can share that with insurers when we're subject to CQS inspection or law society or other professional body inspection. Have I got data to show the types of conveyancing transactions I'm undertaking and the types of conveyancing client I'm acting for? And where there have been changes with regard to work or types of client, have our documentation and processes changed? If we're doing BSA related work, are we aware of some of the recent case law? Are we aware of what has been said by the courts or by government guidance? And have we amended our documentation to take that into account? As far as processes are concerned, have we got evidence to show when our processes have been reviewed and why they've been reviewed? The retainer and report on title need to be under review as well. Early in 2025, we're going to see the Law Society guidance for conveyancers on climate change. Again, I'm told that there's nothing too alarming in that revised guidance or in that new guidance, but again, we need to refer to it, explore it, and make sure the retainer and report on title deal with it. Same thing with regard to the use of revised TA6, TA7 forms. Retainer and report on title must be synchronized with one another. We need to review the retainer. We need to make sure that our report on title is readable and digestible by clients, using interim reports on title perhaps. Leasehold transactions. Be aware of the Leasehold and Freehold Reform Act 2024, some of which is enforced, some of which isn't. And again, we need to explain to clients the bigger picture concerning leasehold ownership. We need to explain to clients the potential implications of the Building Safety Act applying to a building at points in time in the future. With regard to freehold transactions, we need to be aware of the likelihood of greater use of estate rent charges and how the Leasehold and Freehold Reform Act 2024 deals with estate rent charges. This last point is important. When you look at negligence claims against conveyancers, complaints against conveyancers, one of the things that insurers and one of the things that insurance brokers who deal with professional indemnity insurance say is, where there is stress, where there is ill health, where there is overwork and undue and unfair pressure on fee earners, there's a greater risk of mistake. And therefore, it's important that you look after your team and that you also look after yourself. There are hours at work and working hours, and the two aren't necessarily the same. When you're tired, when you're doing things last minute, when you're under pressure, there's a greater risk of mistake. And I know what you're going to say. You're going to say, hey, Ian, get real. Every day we're under pressure. Every day we're overworked, etc. Get real. I get all that, but do be aware that looking after your health, looking after your well-being and others within your team and organization are important. What does 2025 hold? Well, lots of webinars with Stewart Title, our residential conveyancing forum, support staff forum, commercial property forum. All of these things will continue thanks to the continued support of Stewart Title. Again, due to the continued support of Stewart Title, we'll be doing a number of roadshows up and down the countryside where we'll have speakers, etc. And you can come along in person to events, resi in the morning normally, commercial property in the afternoon. So a massive thank you to Stewart Title for that. Remember what Robert said about his willingness and his team's willingness to talk to you about product and your needs. Also, I hope Robert doesn't mind me saying, but the team can also give you training on compliance with regard to title indemnity insurance, which your firm and your team need. So do talk to Robert about that as well. If you have any questions of Stewart Title, there are their contact details on slide. What I'm going to do now is just check to see if we have any questions. And there doesn't seem to be anything in the question section. So I'm now going to have a look at the chat if I can and see if there's anything arising from that. Just bear with me. And again, I don't have anything in there. What I would like to do is to thank Stewart Title once again for allowing me the time to talk to you about the issues today and indeed other issues. To thank you for giving up your time, because I know how busy you are, and particularly at this time of year, the pressures on your time are immense. So thank you so much for that. On behalf of myself and Stewart Title, I hope you have a lovely festive period. I hope you have some time for relaxation and time to forget about work and to concentrate on friends, family, and things that you hold dear. And a Merry Christmas to you all. Thank you once again for attending. If you have questions or queries that you want to raise, now's the last chance before we close the event. Nothing in chat, nothing in Q&A. If you are too shy, feel free to drop me a note. I should somewhere, I hope, have my contact details. There you are. Feel free to drop me a note. Also, please contact Robert and the team at Stewart Title or me if you have any ideas for future training. Stewart Title are always prepared to listen and look at what the profession requires with regard to training, and where I can, I would be happy to assist. But on that note, thank you all very much indeed. Robert, as ever, thank you for introducing the event today. Thank you to Stewart Title for sitting in the background and looking after the technology behind this event. You can get a copy of the recording. You can, and we will make available to you copies of the slides. And I repeat the point, if you have any questions or queries, feel free to drop me a note. Any questions or queries of Robert and his team, contact them at the addresses shown on slide. Thanks everyone, stay safe and speak soon. Thanks very much, bye-bye.